Good afternoon, everyone. Good afternoon. It's so great to see you all. This getting sunnier, but dreary morning, but it's going to be a really beautiful afternoon, it looks like. So we're delighted to be here with you during the transition from a dreary morning to a sunny afternoon. It is my privilege always to get to introduce our endowed lecturers, and this one is no different. We are here to welcome you to the William R. Stewart Memorial Lecture for Labor and Employment Law. Before we introduce today's speaker, Professor Joseph Slater, I wanted to give just a brief background on this endowed lecture and the man for whom it's named. The Stewart Lecture was founded in 2007 to honor the late Bill Stewart. Stewart earned a bachelor's degree in government from Indiana University in 1954 and started law school with us on a full scholarship that October. Just a year into his legal education, Stewart was called to active duty in the U.S. Army and served with distinction for 3 years, rising to the rank of first lieutenant. He returned to Bloomington once his service was complete and completed his JD with distinction in 1959. After graduating, Stewart joined the National Labor Relations Board, where he worked for 34 years, eventually rising to become the board's first African-American chief counsel. His leadership and commitment to excellence prompted President Bill Clinton to award him the President's Award for Distinguished Federal Civilian Service and to characterize his contributions to the NLRB as unparalleled. At the time, he was the first and only NLRB employee in its entire 69-year history to receive this honor, the highest honor of any civil servant can receive. Past Stewart lecturers have been some of the most prominent labor and employment scholars in the nation. They include William B. Gould IV from Stanford University, Laura J. Cooper from the University of Minnesota, Martin Malin from Chicago-Kent College of Law, Sam Begenstos from Michigan Law, Cynthia Estlin from NYU, University of San Diego's Orly Lobel, and this past spring speaker, Matthew Bodie. This year, we are incredibly pleased to continue this list of exceptional scholars with the University of Toledo's Joe Slater. At this point, I will turn the podium over to Professor Velasquez to introduce our distinguished speaker. Thank you, Elvin, for your help with that.
Thank you. So I think you all are in for a real treat with Joe Slater speaking to you today. Joe Slater is the Distinguished University Professor and Eugene N. Balk Professor of Law and Values at the University of Toledo College of Law. He holds a BA from Oberlin, a JD from UMich, and a PhD from Georgetown University. And before coming to Toledo in 1999, he practiced labor and employment law in DC for over a decade. He has been a prolific scholar, and I can't overstate that, especially in the area of public sector labor relations law. He is a leading scholar in that area, and someone that I know Professor Del Schmidt and I also look to in terms of for actionable insights in this. Now, in 2021, Professor Slater was appointed by then President Biden to the Federal Services Impasse Panel. In 2025, he was removed by now President Donald Trump from said panel. So he will have some very interesting and actionable insights on that matter. In 2019, he's also testified before Congress in a hearing called Standing with Public Servants, Protecting the Right to Organize. He's also been a frequent media, quoted in the media as well. He's a musician, which automatically endears him to me. And with that, I introduce to you Dr. Joe Slater.
Thank you for that kind introduction. I am very honored to be here and be joining the list of the people that Alvin just listed, all of whom I admire greatly. I also wanted to say it's a pleasure to speak at Indiana University because you have such a strong labor and employment law program here. It's an honor to speak in front of Ken and Alvin and Deb. I guess I can call them that way. You probably shouldn't, but they are all extremely well known in the field. As to my subject today, which is going to be the attacks on federal sector unions in the last half year or so, I'm reminded of something that happened to me when I was in college, and that was a long time ago. So if you can have your minds drift back to the late 1970s and the Iranian Revolution, and I was at Oberlin, and of course at Oberlin we had teach-ins about everything that was going on, and there was a teach-in about the Iranian Revolution, and this old guy stepped up to the podium, and I still remember this today. He began his talk by saying, I've devoted my entire life to studying the subject of Shia Islam. Nobody much cared. I am happy that people care about Shia Islam now, but I'm not so happy about the reason people care about Shia Islam right now. And I'm sort of in the same situation. I've worked and studied a lot in public sector labor law and in recent years, especially in the federal sector. So I am glad that people are interested in this subject, but I'm not crazy about the reason that people are interested in this subject. One caveat, the topic I am going to talk about today is the subject of ongoing litigation. I was hoping obviously in vain, that there would be some resolution to these issues by the time I got here. So all I can tell you is that there is a lot of litigation. In fact, I woke up this morning, checked my emails and my blogs, and there was literally another case on this just yesterday. So what we have is some injunctions, some stays of injunctions, but no final litigation. But I will tell you what's going on. I'm going to give you some background and history about the federal sector labor relations, and then Trump's executive orders, which have removed collective bargaining rights from somewhere between 2/3 and 3/4 of the employees in the federal sector that have enjoyed bargaining rights for nearly 50 years under the statute. I'll talk about the challenges to these actions, what courts have said, what unions have said, what the administration has said. I'll give you my thoughts about that. And then I will talk about the policy of it all, and then hopefully there'll be some time for questions and answers. Okay, a little bit of background. One big picture fact about bargaining in the federal sector is it is part of generally collective bargaining in the public sector. And the big things to know about bargaining in the public sector is, unlike private sector law, in which most workers got through the NLRA and the RLA, rights to bargain, organize, strike by the mid-30s, public sector labor law developed much later and much more unevenly. Public sector labor law is the first one that was passed in Wisconsin around 1959 to 1961. And even from there was, although there were a lot of states that adopted collective bargaining rights, there were a lot of states that don't. So we have this patchwork in the public sector where a plurality of states grant robust collective bargaining rights to the majority of public employees. That would be true of my state of Ohio and the state I grew up in Michigan. Some states don't allow collective bargaining by any public employees at all. For example, both Carolinas, and some states grant very limited collective bargaining rights to very limited groups of public employees, such as Indiana. But generally speaking, public sector labor law is a matter of state and sometimes even local law. The exception to that, not surprisingly, is the law that covers federal sector employees. That is a federal law. So how did that come about? Well, the first law for federal employees was actually back in 1912. There was something called the Lloyd-La Follette Act. The Lloyd-La Follette Act gave federal employees the right to organize into unions, meaning they couldn't be fired for joining a union, but no rights beyond that. No organizing rights, certainly no strike rights or bargaining rights beyond just, we can't fire you for being in a union. That, interestingly, was more than most public sector employees had through the 60s. It wasn't until the 1960s that, between the passage of some collective bargaining statutes and courts finally deciding that there was a constitutional right for public employees to organize and organize only, the federal employees always had a right to at least organize without being fired. Okay, zip up in time to 1962, and President Kennedy issues an executive order that gives some basic bargaining rights to federal workers. And this order, relevant to our discussion today, excluded some public workers or some federal workers on the grounds of national security. It excluded employees in the FBI and the CIA. Presumably that was for national security concerns, but there was no explanation given in the executive order. Next big thing that happened in 1969, President Nixon issued an executive order that added a crucial feature. He added the two independent agencies that could resolve bargaining impasses in the federal sector: the Federal Mediation and Conciliation Service, which would do mediation, and the Federal Service Impasses Panel, which was what I was serving on, to settle bargaining impasses by a form of what's called binding interest arbitration. Binding interest arbitration, by the way, is the most common way to settle bargaining impasses in the public sector. There's about 10 states, including Ohio, that allow most public employees to strike, but the much more common method, even in the states that give robust collective bargaining rights to public workers, is to say you can't strike. If you get to impasse, you have to try something like mediation, and then eventually get to something like binding interest arbitration, in which arbitrators order the terms of contracts, not to be confused with grievance arbitration, where arbitrators are interpreting the terms of contracts. Anyway, Nixon administration created this method to solve bargaining impasses, and that's what I and my colleagues were doing at the FSIP. So, and here's a sentence I've never said before in my life: thanks, Dick Nixon, for creating a job opportunity I would take 52 years later. All right, so then the next thing that happened, creating the current law that governs the federal sector, in 1978, there was a law passed called the Federal Service Labor Management Relations Act, the FSLMRA of 1978, which I am going to call the Act because it's hard to get all that out. This act created the Federal Labor Relations Authority, the FLRA. It's a 3-member panel that functions much like the National Labor Relations Board. It handles union elections and adjudicates unfair labor practice charges. This act also created a body called the Merit Systems Protection Board. The Merit Systems Protection Board is essentially the civil service body that adjudicates individual employee cases. When an employee has civil service protections, for example, that says you can only be fired for just cause, the individual can adjudicate those cases through the MSPB. Now, so we now have the act created a lot more rules, labor law rules for federal sector employees. Most of the rules in the act for federal employees would sound familiar to anybody that does any kind of labor law work, but there's a couple of interesting provisions that are relevant here today. One is that unions in the federal sector, generally speaking, with a couple of exceptions, cannot legally negotiate about compensation. Indeed, the entire world of compensation in the federal sector is outside the scope of bargaining. And also relevant to us today, federal sector unions can't legally strike. I don't know how many of you remember or read about the PATCO strike of 1981, but that was an illegal strike by federal employees. And one interesting provision in the federal act that goes beyond what state laws typically do in terms of penalizing illegal strikers is the federal act says that striking against the federal government is a crime. And indeed, some of the PATCO strikers went to jail for striking. And now we're going to get to the key part of the federal act, which is going to be the main topic of my talk today. the act permits excluding employees if their work is engaged in significant part in national security. So there's three provisions. We're going to talk mostly about one today. One provision just excludes the certain agencies from the start. Section 7103A3 of the Act excludes the FBI, the CIA, the National Security Agency, and the Secret Service from coverage. Second, and this is the key one today, Section 7103B1 gives the president power to, and I quote, exclude any agency or agency subdivision from coverage if the president determines that the agency or subdivision has as a primary function intelligence, counterintelligence, investigative, or national security work, and the provisions of this chapter cannot be applied to that agency or subdivision in a manner consistent with national security requirements and considerations. So what this provision is saying basically is if the president determines that this particular agency or this part of this agency is doing work, the primary function of which is intelligence or security work, and the president determines that you can't apply the normal collective bargaining rights to employees consistent with national security requirements, then the president can say this group of public employees doesn't get collective bargaining rights. This provision was invoked fewer than a dozen times between 1978 and last spring, and the best way to describe the way it was applied was surgical. There was a number of small discrete sub-agencies here and there, attorneys in the criminal division of the Justice Department that were prosecuting the Manuel Noriega case, for example. But there is, the Trump administration has gone far, far beyond it. And then there's a third exception that allows, again, even more sort of surgical exclusions if particular employees within a bargaining unit are considered a national security risk. If they have collective bargaining rights, they can be excluded. But we are interested today in 7103B1 because that is the authority that President Trump has used to take away collective bargaining rights from literally, depending on the estimates, 2/3 to 3/4 of the federal employees who have enjoyed collective bargaining rights prior to these executive orders. Now, I see that there's a lot of law students in the crowd, so the thing you might think about is, well, was there any definition in the statute of what we meant by national security work or work that primarily involves national security work or intelligence? And the answer to that is no, there's no definitions in the act about that. And the second thing a good law student would probably say to themselves is, well, is there relevant legislative history? What did we mean by these provisions? And the answer to that is no, there's no relevant legal history about this either. So the attacks that presaged the attacks of the Trump administration began in a smaller but still significant way under the Bush administration. The Bush administration fought hard, for example, to exclude, when the Department of Homeland Security was created, to exclude all of those employees from collective bargaining rights. There was a fight about that, and the Democrats prevailed in getting into the statute that created the DHS language that said, and these employees should have collective bargaining rights. That has not stopped President Trump from trying to take them away, but that was a fight. And again, even that was considered radical. At the time, Senator Feinstein, at the time of the creation of the DHS, Senator Feinstein said, look, there's been a history of Department of Defense civilians with top secret clearances who have been union members. And indeed, all of the agencies that were part that were separate agencies that came together to become the DHS. All of them had collective bargaining rights prior to the Bush administration, or at least prior to the Bush administration trying to take them away. And there was a ongoing fight, by the way, about TSA employees. TSA employees, they didn't get collective bargaining rights until the Obama administration granted them some collective bargaining rights. But what you also see back then is the intellectual underpinnings of these attacks. The Heritage Foundation, for example, around the time that they were urging Bush to take away collective bargaining rights from federal employees, the Heritage Society issued a report that said, and I quote, "Federal sector unions are at best responsible only to their members. At worst, they represent the permanent government acting on its own self-interest." And if that sort of reminds you of something, this was the origins of the deep state language that you heard in the first Trump administration and is being acted out with a vengeance in the second Trump administration. Okay, so what has Trump done? In March of this year, President Trump issued the first of two executive orders he was going to issue on this. This was Executive Order 14251. And again, he cited in this section 7103B1 of the act that says, again, the president may issue an order excluding any agency or subdivision thereof from this chapter if the president determines that the agency or subdivision has a primary function of intelligence, counterintelligence, investigative, or national security work, and the provisions of this chapter can't be applied to that agency or subdivision in a manner consistent with national security requirements and considerations. Again, this order applied broadly, probably to about 2/3, initially at least, 2/3 of the employees that currently had collective bargaining rights among, well, we can get into the list of these others, but, almost all the employees in the Department of Defense, Veterans Affairs, National Science Foundation, Coast Guard, Department of Homeland Security, State Department, Department of Energy, Department of the Interior, Environmental Protection Agency, Treasury Department, Justice Department, and some other agencies within the Department of Health and Human Services. Interestingly, this order did not exclude employees who were police or firefighters within or had security roles within those organizations. And if this sounds vaguely familiar to people who follow public sector labor law, in 2011, Wisconsin amended its statute governing public employees to take away, essentially, collective bargaining rights from all public employees except for police and fire. Iowa did something similar a few years later. So all the employees in these agencies, except for people that do police and fire type of work. So what was the justification in the EO for doing this? A fact sheet accompanying this executive order said, union activities impair agency functioning in a manner that could undermine national security, for example, by impeding the removal of employees for poor performance or misconduct. And the fact sheet accompanying the EO added that the act, quote, enables hostile federal unions to obstruct agency management, end quote, and that, quote, certain federal unions have declared war on President Trump's agenda. All right, so in my original version of this speech, I was going to go through all of the individual cases and what was going on in all of the individual cases and the responses to them. At this point, there's just too many. Again, this very morning, there was a new one at the Voice of America. So I'm not going to give individual cites. If anybody wants individual cites, feel free to send me an email. But I'm going to try to sum up what the unions are saying and what the administration is saying, and give the main arguments on both sides with some examples. Okay, so initially, the first litigation on this was in California, and a district court in California enjoined, excuse me, they probably didn't enjoy it, they enjoined the EO. Among other things, it said, the court judge said, well, we don't have the intention of second guessing the president's national security determinations. The government itself, quote, has had a hard time saying why certain agencies have a primary function of national security. The court also found at least some evidence of a plausible First Amendment violation on the grounds that the administration was taking away the collective bargaining rights of unions that were opposing, in some ways, the president's policies. And the court found a likelihood of irreparable harm and that the balance of hardships favored the unions. The Ninth Circuit then stayed the injunction and said, among other things, that they thought the government was likely to succeed on the merits and that the union had not shown it was irreparably harmed. As for the success on the merits issue, the court said something interesting about the First Amendment claim. It said, even assuming that the unions had made out a prima facie case of retaliation because of their speech, we think the administration would have taken the same action in removing collective bargaining rights, even absent the speech. The court also showed some deference. It was unclear to the court whether it could question the president's determination that certain unions have national security implications. And there was similar litigation in DC, and there have been more and more cases filed, again, through September, through October, literally through yesterday. Another thing that happened in the background is in August 28th, the president issued another executive order excluding even more agencies. This is how we get up to maybe up to 3/4 of the employees. And I'll tell you facts about one case that I find amusing and illustrative. This order made it clear that the Patent and Trademark Office and the National Weather Service were covered, and those two unions filed a claim in the District of DC, and that litigation is pending. But what I think is illustrative about the case is this is, I think, a strong case we really have nothing to do with national security and the things that the executive order say are wrong. For example, the executive order fact sheet that excludes the National Weather Service says, well, the National Weather Service provides forecasts that are used to plan U.S. military operations. And therefore, that's a national security. And the unions say we literally don't do that. And again, I don't have personal knowledge of that. But the question is, does that matter? I think legally, does it matter whether the things that are said are true? And similarly, the union representing employees of the Patent and Trademark Office, the fact sheet says, well, one of the things that the Patent and Trademark Office does is they review proposed inventions to see if they can harm national security, and if so, they put those in a different pile and do different things with them. And the union says that is like something that like 3 guys do. And I mean, they didn't put it quite that way, but essentially it's an incredibly tiny part of our work that only a small handful of employees do. And so the question is, does that matter? And again, they raised a First Amendment claim saying that you are retaliating against us because we opposed the firing of probationary workers, which is a whole other thing that's going on. And I like this particular line from a Department of Agriculture employees suit, similarly to this isn't what we really do. A union rep said, and I quote, revocation of collective bargaining rights for 2/3 of the federal workforce, including our plant inspectors whose primary adversaries include boll weevils, grasshoppers, and crickets, has nothing to do with national security. So, you know, if nothing else, there's some good quotes to come out of this. They say rather it's an attempt for President Trump to punish his political enemies. So another legal argument that came out of this, and this is from the PTO case, what should the standard be? Because again, one of the overarching issues here is the statute says, if the president determines, ... And so one of the issues the courts are struggling with is how much can you look behind a president just asserting things? What if he's wrong? What if the National Weather Service really doesn't do this sort of thing? The PTO union, I think, offered this interesting legal theory. They said that under the statute, there should be a rebuttable presumption of regularity, in the sense that, you know, without contrary evidence, the court should assume that the president was correct. These folks are, in fact, involved in national security. But that it is a rebuttable presumption, and that the unions or the affected employees should be able to put on evidence to show that's not really right. What they said in the fact sheet, what they said in the executive order is factually inaccurate. Okay, so another thing that is going on at the same time is the administration has been terminating collective bargaining agreements that these unions have. They're not just saying you can't bargain anymore. They're saying we don't have to abide by the union contracts that we've entered into. And I'll just say as an aside, one of the reasons that the Ninth Circuit said there was going to be no irreparable harm to unions was that they said, well, they still have their contracts while this litigation is playing out. But then they started eliminating contract rights, including the Department of Veterans Affairs contracts that covers, and this is not an exaggeration, more than 400,000 employees was terminated. So big picture, you know, we've had litigation, we've had, which is ongoing, we've had lower courts stay these orders, we've had both the DC Circuit and Ninth Circuit stay the injunctions that the lower courts entered into. And that's where we are. We don't have anything like a final decision on any of this, and the facts on the ground keep changing. So let's talk about the arguments, because I think some of these arguments are interesting in a legal sense, even beyond this particular application. Again, starting with the statutory language. So do we say, hey, the statutory language says if a president determines that these people affect national security in certain ways, they can take away collective bargaining rights. That's a plausible argument. On the other hand, was this ever seriously intended to say, well, you know, we can do this for almost the entire federal sector. The clear majority of the federal sector falls under this. When we have a statute, the Act from '78, that begins, you know, we find that collective bargaining in the federal sector is in the public interest and supports the public service. I mean, can you say that there's this little, like one little catchphrase in the statute that allows you to unwind the whole rest of it? Second, as to the statutory language, again, how much can you look behind? How much can you look behind whether the assertions in an executive order or in a fact sheet are actually true? And if you can't, I mean, if both these arguments fail, and they might, but if both these arguments fail, that means literally President Trump could say every single federal employee implicates national security work such that they should be exempted, and no one in the federal sector has collective bargaining rights anymore, despite the fact that there was a law in place for, you know, again, almost 50 years that says the vast majority of federal employees should have collective bargaining rights. Second, what do we make of the idea that the president has, at least thus far, been exempting from the statute people who do police and fire work? Is there any kind of claim against that? Unions have tried to say so far, and we'll see if this succeeds. Unions have argued that this is arbitrary and capricious in violation of the Administrative Procedures Act, and they've also claimed that this is more evidence that there is a First Amendment violation, and some unions have tried the argument that this is an equal protection violation. That sort of argument has been tried before in the public sector when states give certain types of unions much more robust bargaining rights than other types of public sector unions, especially when it appears that there's a First Amendment implication that you're supporting the unions that like you and you're taking away bargaining rights from the unions that opposed you. That came up in the litigation about Wisconsin Act 10 back in 2011. Some lower courts, both at the state and federal level, bought it, that this is some kind of combo equal protection First Amendment violation when you are, again, retaining collective bargaining rights for the unions that support you and taking away collective bargaining rights from the unions that didn't support you. A couple of lower courts bought that back in 2011, but also back in 2011-12, both the Wisconsin Supreme Court and the Seventh Circuit didn't buy that. You know, unions aren't a protected classification, and therefore there's no equal protection problem. And even though it may not be great to reward and punish your enemies like this, that doesn't make it a First Amendment violation. One interesting background fact about the public sector generally is there is a new Supreme Court in Wisconsin which might look at that differently. But anyway, as far as the federal sector, there is this lurking issue about, you know, what about the fact that you seem to be taking away, you're saying all of these agencies have all these employees whose work implicates national security, so we're going to take away your collective bargaining rights, and but not the police and fire folks. Can you make anything out of that? And then there's a third argument I want to talk about, which is procedural issues. So far, these claims have been brought in court, but one thing the administration has been arguing about these cases and cases involving firings and rifts in the federal sector generally, the administration is saying these cases don't get to go to court first. The FLRA is structured like other labor boards are structured in the sense that claims, for example, of unfair labor practices have to go to the agency first. So the Trump administration, and so far it hasn't quite prevailed on this, but it may, the Trump administration is saying whatever arguments you have, unions, these need to go to the FLRA first. You cannot go directly to court. And for example, in mid-September, the Trump administration said, you know, we can cancel our union contracts. That, you know, the union wants to say that's an unfair labor practice, they can say that's an unfair labor practice, but that has to go to the FLRA because the statute generally says that these types of cases, unfair labor practices, have to at least start with the FLRA. But here's the problem. There really is no effective FLRA anymore because Trump has fired the members of the FLRA, and of course there is litigation pending on that, but the FLRA currently does not have a quorum. The FLRA currently does not have a general counsel. So there's a question of, can you force people, can you force unions to start out at agencies that are disabled, especially when you are the one who disabled the agency? There is an interesting analogous case from the Fourth Circuit on the MSPB. Again, the MSPB is like the civil service body. And there is a case that, you know, normally, I won't get into the details of this case, but involves immigration law judges of all people. But the argument was you can't take this case to court, immigration law judges. You have to go to the MSPB first. The MSPB, similarly, Trump has fired members such that there is not a quorum, so the MSPB would not be able to hear these cases or make decisions on these cases. The Fourth Circuit has suggested that, if these agencies really are disabled, and there's a subtext, and disabled by the defendant in this case, maybe that means the jurisdiction stripping provisions of the act shouldn't apply. And I think that's an interesting argument, which again, we don't have a decision on. The Trump administration has asked the Fourth Circuit to reconsider that decision on bank, and we'll see what happens there. Okay, because I do want to leave some time for questions and comments. I want to talk, and also because I don't have anything else to say about the law, because the cases are just pending, and we'll see what happens. But I do want to talk about this as a matter of policy and not just legal issues. Because you could say, well, President Trump, takes away collective bargaining rights. Maybe the next Democratic president will restore collective bargaining rights. What's the better approach here? I think these fact sheets and the things that the president has done to either cancel union contracts or alternatively to just say you guys can't collectively bargain anymore are based on inaccurate stereotypes about unions. And I think there's an argument to be made that we should push back, not just as a legal argument, but as a policy argument, as a political argument. We should push back on the idea that unions make employers less efficient. In my view, and based on my research, that is an opinion which, while it is held strongly in certain circles, is not backed up by studies or evidence. I will say that what I did on the FSIP was to deal with parties from the Bureau of Prisons to the Veterans Administration to, other less sexy agencies, civilian employees all over the place. What I did on the FSIP was deal with folks who were trying to come to contractual agreements. And what I saw there and what I saw in my practice as a union lawyer back in DC, look, unions aren't always right. I don't think I would say that. I don't think anybody would say that. But managers and supervisors also aren't always right. And what collective bargaining does is it forces a process where the parties have to sit down and talk about their interests. And what I saw at the FSIP and what I saw when I was a lawyer is that when the parties sit down and talk about their interests, look, workers know things about how work is done. Workers know things about how they will work most efficiently. Management has real interests too. Management knows things that workers don't. But if you get them together and you say, hey, why don't we talk about what are your interests really here? What do you want and what are you afraid of happening? And you can say the same thing to the union. What do you want and what are you afraid is going to happen? You get the parties together and you get agreements that can satisfy both sides. And in a way that if no one's ever forced to talk to each other, you won't get. And we also want workplace protections so we can get better quality people in federal service. I don't know about you, but I know I have former students, alums now, who went into good federal jobs, Department of Labor, Department of Justice, other types of good federal jobs, who are leaving because the Trump administration has made being a federal employee so unpleasant. So again, what's going to happen? I don't know. I will just conclude by saying we could have a situation where the courts uphold everything that President Trump is doing. That would not be what I think would be buying the best arguments, but courts don't always do what I think is buying the best arguments. I've learned to live with that. In which case, the employees are going to stay unionized. They're not going to go away. The American Federation of Government Employees is not going to go away. They're going to do things that that unions did historically before they had collective bargaining rights. They will try to represent their members under other laws, civil service laws, other types of labor and employment laws. They will try to act politically to protect their members. They will distribute information, so it's not going to be literally the end of the world. The unions will still exist, but there will be something significant that will have been lost in this process. And you could say again, well, maybe, President Newsom or whoever in the next presidential election could restore all of these collective bargaining rights to these people. But it's not a good way to run a railroad, I will tell you. It's not a good way to run a railroad, and it's certainly not a good way to run labor relations, to say, well, every 4 or 8 years, a bunch of you get robust collective bargaining rights, but then in 4 or 8 years, you're not going to have those rights anymore, and your contracts are going to be taken away. So I hope that what happens is that the courts will think a little bit about the practical implications, the purpose of this act, which of course you could always repeal the act, right? But to do all of this by executive orders, undermining the purpose of the act in ways that I think will be harmful to not just federal employees, but the functioning of the federal government in general. Thank you, and I'll be happy to take questions, but I know Alvin has something first.
Sorry, before we do Q&A, I just have a quick housekeeping announcement. For our virtual attendees seeking Indiana CLE credit for this lecture, the attendance code is 86637, 86637. The code and submission instructions will be sent out in the chat on Zoom. Please look out for that. And as a reminder to our in-person attendees seeking CLE, there is a sign-up sheet available outside the room. Please sign up to receive credit. The attendance code is only for virtual attendees. We'll now be entering our Q&A period. If you could, please stand up before you ask your question so that we can make sure to capture it for our virtual attendees. Thanks.
Hi, my name is Alvin. I research and teach national security law and intelligence law, but I know nothing about labor law.
Well, I know nothing about national, so we're...
Terrific, so we're a good match. It is, for that reason, I'm curious whether in any of these cases you're mentioning, either in amici or in advising the clients, is there any national security scholar or lawyer-based people? In particular, I'm thinking about one set of arguments that are familiar to national security scholars, which is to treat as suspect any use of categorical and en masse determinations by a policymaker of any kind, that something is a national security threat, that those are presumed to be non-due process protected by design, that they are not scrutinizing each individual determination, which seems to be the way this was done.
Oh, I love that question. As to whether there are any national security experts as amici in these cases, not that I've seen, but again, and this may sound like a lame excuse for a law professor to make, but there are so many of these cases and so many briefs, and I was trying to keep up with them, so I might have missed something. But I like your argument very much, and it is consistent with the union's general arguments that you are using, a meat cleaver as opposed to a scalpel in these situations, and I like that a lot. We should talk. Yeah.
Hi, I'm Jacob. I'm at 2L taking labor law. So,
all right, good for you.
I was hoping you could go a little more in depth on what you were discussing earlier about the Ninth Circuit's kind of hemming and hawing over whether we should just give the president deference on matters of making these determinations on these certain issues. Because my answer would certainly be, well, of course the courts should be involved. Of course, you should hesitate to give them deference because, that's why we aspire to have the judiciary and have checks and balances. But I was curious what the
Yeah, no, okay. So I'm sorry, I didn't mean to talk over you. But yeah, so far, whether one approves of this or not, the courts have been skeptical of looking too far behind the president's determinations. And the Ninth Circuit says things like, well, even if, still the union hasn't shown irreparable harm or the union hasn't shown a First Amendment violation, I think it's a tough thing. And I think there's an analogy in some cases where, as I'm sure people in this room know, the president has a power to do things if there's an emergency, and there's a lot of litigation over whether, courts can look behind a president's determination of emergency. But the argument on the other side of what you made, and obviously, I'm personally very sympathetic to the argument you made. The argument on the other side is the statute says if the president determines, and who are we courts to say, the president is wrong about what involves national security. This is going to be the test, though, of how far that goes, because if the courts really say we can't look, past national security, Trump's going to go from 2/3 to 3/4 to, 90 or 95% and say, yeah, they all affect national security. Courts, you can't look at it. So I hope that the prospect of that will give some courts some pause, but not a lot of that yet. But I mean, I buy your argument. Yeah.
Thank you for coming to our school and giving this great lecture.
I appreciate that, and I appreciate the invite.
My name is Colin, I'm 3 up here. I'm curious, obviously this isn't true for TSA. You mentioned that they only got the bargaining rights under the Obama administration. I imagine that some of these bargaining relationships were quite mature. So is the cancellation of these CBAs, is something lost there that won't come back even if those rights are restored, like maybe interpersonal relationships or institutional knowledge?
I think absolutely. I mean, one of the things that labor law depends upon is, having some experienced, skilled people on both sides, right? You need skilled, experienced people on the HR side or the management side. You need skilled people on the union side. And yeah, I mean, there's still going to be HR jobs, right? There's still going to be, did Jane steal the computers and should I fire Jane or something like that? Individual cases, and unions are going to still do things. They're going to, if they lose all these cases, they're going to do things. But again, the process of collective bargaining is, as you say, something that relies on these sorts of relationships. And some of these contracts have language in them that go back decades, and it's hard enough to find people who remember, why did we put this? I mean, I was doing things at the FSIP where people were saying, well, this language has been in our contract for like 20 years. No one's around that even remembers that anymore. That sort of problem will get a lot worse. Like, why did we decide to do this in the first place? I think that's a very insightful comment.
Yeah.
Hi, I'm Michelle Zeiler. I'm at 2L. In a previous life, I worked for the American Federation of Teachers, and I was actually in Wisconsin in 2011 and 12.
Lucky you.
Yeah. Well, I mean, from DC, but so us and AFSCME, other unions tried to organize workers back into the union, like sort of to recapture is not the right word, but to encourage voluntary joining. Is this illegal for government? Can government workers rejoin AFG or Treasury, or is that prohibited? And if they are allowed to do that, are those public sector unions doing that?
The short answer is yes and yes, but since I'm a law professor, I can never give short answers. So the slightly longer version is yes. I mean, you can still join AFG, the American Federation of Government Employees, or other unions that represent federal employees. AFSCME represents some, NTEU represents some. You can still join them. The consequence of these things are simply that you don't have collective bargaining rights, and apparently even the current contracts you're under are eliminated. But these unions will still carry on, and they'll still do things, although, I would expect something like in what happened in Wisconsin, which is, declining membership, right? Now, maybe it's a little different than Wisconsin because, if I was an organizer for AFG right now, I would say, we just got to get through another 3 years, elect a Democrat, and I'll give them all our rights back. But it's going to be a challenge. And the other thing that plays in here is, these are our jurisdictions, the federal sector in Wisconsin in more recent years, and all the public sector since the Janus case, that are what they call right to work jurisdictions that ban union security clauses. So even if, you can't require anybody to pay dues, but that's been true in the federal sector forever. Questions? Yeah.
Well, I studied corporate law, and I often think, what if we were USA Inc. instead of the United States of America. And actually, it might lead to better governance because every employee and every representative and senator would have fiduciary duties to operate in the best interest of the country as a whole and themselves. So in thinking about the standard to apply to the president's determination, perhaps an analogy would be to say, you know, what kind of standard applies to a board member making a decision, and it is acting in good faith on a reasonable basis and in the best interest of the company and its shareholders. In this case, those would be the citizens of the United States.
So I love that as a suggestion. I mean, what we have is a president who, I'm going to be careful what I say here.
You don't have to.
I'm being recorded, no. We have a president where it's not entirely clear to me he views himself as acting in the interests of the entire United States as opposed to his constituents. You know, I've now said that on recording, but I truly believe that. You know, the argument on the other side is a deep state argument, as Trump is saying, look, you know, we tried to do things in our first administration, but it was all these, I don't know, people investigating boll weevils and the agriculture department that kept me from fulfilling my agenda. And it was, you know, I get this idea that they think that throughout the government, secretaries and paralegals and others are slow walking the agenda, which I would say both as a representative of federal sector unions and as a member of the FSIP, I never saw any of that. But the other side really believes that. They believe that, you know, it's a festering hive of leftists, of government employees who are trying to undermine the president. And that's, I think, what is driving this. That was driving things back under the Bush administration as well. Yeah.
Thanks very much for a provocative talk.
I thought it wasn't so provocative until the last little bit, but go ahead.
So, suppose the unions lose overall.
Yeah.
And several years hence, whether it's 3 years or 10 years, there's an opportunity to rebuild.
Yeah.
What would you do differently in restructuring federal labor law so that it's more resilient?
That's a fantastic question. And the first thing I would say is what that would require was a statutory amendment, right? Doing things by EO like this is kind of crazy. So imagining a world in which there was a coalition that could pass a amendment to the Federal Labor Relations, the Act, I think the first thing you have to do is you have to set up some definitions for what we mean by national security, establish what kind of court review there can be. I mean, because obviously there are some types of employees. I mean, nobody wants the CIA, well, maybe not nobody, but I would not argue here that the CIA should be unionized, but there has to be some, you know, whether it's in the statutory language or in the legislative history, or somewhere, some cabins around this is where I would start to avoid this particular issue. Say, what do we mean by national security and what can courts evaluate and not evaluate? You know, and if I had my druthers about revising the statute more broadly, I personally might make more compensation issues negotiable, and I might take away the part that makes it a crime to strike. But I think to address this problem, you need some statutory amendments about the national security exemptions.
Please join me in thanking Professor Slater for his